Joining us to discuss, national trial attorney Michael Jaafar joins us this hour. Michael, great to see you. Let me begin just by asking about this idea of, first of all, you want to make the judge happy. You want to, of course, be frugal with your time regarding the jury. So if you have the opportunity to call witnesses out of order, you do it. But as a defense attorney, is that something you want to do, or would you be worried about that affecting the way you want to run your case and the way you want to make your arguments?
I would have been very disappointed. I would have probably objected to it, but his defense attorney is a pretty solid attorney. He must have thought it was advantageous, but you have to get in the rhythm of getting ready to examine a witness, especially when your client is facing several counts that any one of which could send him in jail for the rest of his, conceivable life at his age. The witness out of order that needed a translator was expected, was somewhat foreseeable, but this witness here, that kind of shocked me a little bit. And so you're kind of rushing through the trial. You could just call it a day. Some of these trials are 4 weeks long, right? So why condense it by a half a day, right? So to me, that would have shocked me. So to answer your question, Michael, I would have been a little bit perturbed unless I was prepared to examine this witness. And you saw his examination was pretty good, and it was an impactful witness.
Yeah, it seems to me, Michael, that maybe there was some understanding that this could happen because, again, number one, the witnesses are there already. A lot of times you don't call them in if you don't think you're going to have the opportunity or chance to call them unless they want to be there on their own, and they're allowed to do that. But also, this is the kind of case, Mike, that I feel like it's really just about telling the story about what happened and what happened after. So there are certainly fact patterns where I would say, you know what, the last thing I want is to start my case in the middle of the state's case. But this is one of those cases where it's really, again, just about what happened in that moment, what happened after. Not sure it's as impactful calling witnesses out of order than some other cases.
I agree. And as you and I both know, we went to law school, we took all the exam questions, right? And we know that our professors were very sadistic, and they gave us fact patterns that were right down the middle, right? The exams in law school never asked you, hey, what are the elements of murder one, right? And the difference between murder one and two. They said, here's a fact pattern. It could go each way, argue at both sides. And so that's what this fact pattern is turning into. Hey, your client colorably defended himself. He has a colorable argument of self-defense. This happened in a state that did not give him a duty to retreat. It did not impose that duty. And oh, by the way, he lied to investigators after the fact and lied to the nurse about a murder weapon, and it was a complete lie. Go ahead and argue it. And so on top of all that, let's call witnesses out of order, right? And so you have to bring in 2 of your witnesses during the case in chief for the prosecution, and then after that, bring on your case in chief, but you can't recall well, you could recall those witnesses, but maybe you don't want to. They already have their testimony on record. So this thing is just a pure law school exam question, and I would be kicking myself if I was the defense attorney trying to keep track of all of this stuff.
Yeah, it's interesting. Yeah, and I agree with you 100%. And what folks have to remember, Michael, and I'm sure you'll agree with me, the whole purpose of these questions in law school by these professors is to torture us as students. See, right? At the end of the day, they want to torture you, right, and make you think, well, exactly. At the end of the day, I'm sort of exaggerating. They want you to think on both sides of the coin. And this is exactly one of those cases, you're exactly right, where you really can make cogent arguments on either side.
Yeah, absolutely. You have a colorable self-defense claim in a state that did not require a duty for you to retreat, which helps the defense, but it doesn't completely help the defense because it's not a stand-your-ground state. If it was a stand-your-ground state, this is right in the middle, right? And then after that, your client, the defendant, lied to investigators, and oh, by the way, he may have been not guilty of the first crime, the murder, but then of the subsequent crimes, the attempted murders of the subsequent kids. I mean, this is absolutely one of those exams where it was always on a Tuesday morning, Michael, and you didn't have your coffee, and the exam began, and you knew you failed that exam. So yeah, that's what this is.
Well, I've never failed an exam in my life, but that's besides the point, Michael. That is besides. No, I'm just joking. Mike, stand by. We do have to take a break. All right, joining us to discuss is national trial attorney Michael Jaafar. And Michael, there's an inescapable fact about this case, and that is the viciousness of the attacks. We're talking about, I mean, certainly you could say he considered that he was in concern for his life or great bodily harm, being by the water. I think that sort of ups the ante a little bit. But the viciousness of the attack cannot be escaped. What role do you think that might play in this case?
I think the viciousness of the attack matters, because if all he did was, I always said from the beginning of this case, you wish that your client used a gun, not a knife, because guns are, quick, momentarily, instantaneous, right? With a knife, it's so intimate, Michael, and it's so vicious, it's so upfront and close, and it takes so much longer. You can stab somebody multiple times. So the viciousness, for somebody to die from a knife wound, it has to be vicious. It can't just be a momentary, just a quick incision. I think it plays a lot, especially since he's facing multiple felony counts, right? So you have to consider that it's emotional. It's jarring. It's icky, right? It really sucks for the defense that they have to deal with that. But it's going to play a big, significant role.
Now, the defense dealt with it, I thought, pretty well on the cross-examination of this witness, Michael. They basically tried to suggest that some of the depth, and you heard it was very deep wounds, and even the length of it might have been caused by people actually attacking him. They might have jumped on it, or as they were coming at him, that's why it went further in, and as they moved around, that's why it went up their bodies. It wasn't something that he intended. I think that, even just a suggestion that there's another explanation for the viciousness of the attack, very important for the defense.
In the prior block, we were talking about how difficult it is that they were bringing witnesses out of order. I just thought of something. With what you're saying right now, the problem for them bringing the witnesses out of order is the defense shows their hand, and so we know that their argument is nothing happened to these other victims until he was basically knocked out in the water. So to your point right now, with the viciousness and the way the defense are conditioning it, it plays right in line with their argument, which is nothing happened until he was knocked out, right? He's an older man. These are younger kids, and he was surrounded. It was a wet environment. He was knocked out, and then he started using the knife. So the viciousness of it, the impact of the knife, how it was dug in deep, he only did that because he truly feared for his life. He's a Boy Scout, never done anything like this before, never been arrested, right? Why else would he have done this? The heinousness of it, and dug in the knife and literally twisted the dagger, other than the fact that he was in fear for his life and he was punched, knocked out, he was almost unconscious. And so that actually explains why why the defendant had such vicious insertions of the knife.
Finally, I want to ask you about the escape. And, well, again, I hate to call it escape. The aftermath, the things he tells other people, all seeming to minimize his involvement in this situation. Certainly, they'll be charged, the jury will be charged, that can be taken as consciousness of guilt. What do you make of it, and how important were his actions after?
It's very simple. He lied because he didn't know he was on tape. It's that simple. Just think about it like this, right? Let's just say there's no tape, right? There would be a debate. None of us would know who brought the knife to the scene of the crime, right? So he lied because he thought there was no record of what he did, right? They wouldn't have even brought charges against him if he took a knife, like he said, took a knife from another kid and stabbed that kid. Their charges would never have even been brought in this case, right? So the jury is inside the jury room, it's gonna be known. Listen, he didn't know he was recorded. Maybe this is evidence of consciousness of guilt. At a very minimum, he tried to get away with it. His defense attorneys, we know what they're going to say in the closing argument. They're going to say the only thing they can say, which is he panicked, he was upset, he was afraid, and that's why he lied. He had he made a mistake, but that doesn't mean he did anything wrong.
All right, fair enough. All right, Michael, stand by. All right, still with us to discuss, National Trial Attorney Michael Jaafar. Michael, so much to discuss here. Just as a baseline, as I mentioned, involuntary manslaughter in Michigan is interesting because many states, the max you can get is like 3 years, 5 years. The max in Michigan is 15 years, but it's 1 to 15. There's a big gap there because I guess there are a lot of fact patterns that can fit into involuntary manslaughter, give some discretion to the court and prosecutors in asking for time, and I kind of like that. Here we have a wide discretion. The state wants 10 years. They want to go above the recommended sentence of 7. The defendants want 2.5 years, which would be time served. They would essentially walk out of jail, which is below, a downward departure from what is recommended for first-time offenders. I want to get your thoughts on where you stand on the sentence in this case.
I have some insight on this. I called an actual felony judge in Detroit, right? This is in the Pontiac courthouse, right? This is about 40 minutes away from Detroit. Same system, same law. I called this felony judge. He's a good friend of mine, and I asked him. He's the judge on these cases all the time, right? I didn't tell him I was talking about the Crumbley case. I said, Judge, what do you think the sentence would be with these facts and these convictions, 4 involuntary manslaughter convictions? He didn't even hesitate. He said credit for time served about 6 months, upwards of about 2 years, depending on their prior history. What's the prior history? I told him the prior history. He said probably 6 months to 2 years, right? I didn't tell him it was about the Crumbley case. Then when I told him about it was the Crumbley case, he stepped back and said, it's a problem because obviously everybody's watching it, and so it's a difficult spot for that judge. I don't envy that judge. Michael, these judges run for elections. This judge lives in that community. Everybody's watching her. She knows there's nothing she can do to bring these kids back, but everybody in that community is going to remember what she did. The sentencing guidelines in Michigan are not mandatory for these judges. Theoretically, she could get them 60 years. That would be so unprecedented and so heinous that it would be brought back on appeal. But theoretically, she could do that, right? The sentencing guidelines are not required by these judges in Michigan. Up until a few years ago, they were required. Now they are merely guideposts, right? A judge could deviate from it. Unfortunately, I think the judge is going to deviate in this instance because of the fact that everybody's looking at her. And I'm sorry to bring up the fact that she's running for re-election. It's just, I'm analyzing the case. I got to call it as I see it. I don't know this judge personally, but if I was in the quiet of her mind, that's got to play a big factor, right? And the allocution and the witnesses that are going to come in and the family and the victim impact statements, that's going to play a role. She's going to have to go above the sentencing guidelines on this one. I'm not saying that's right, but she's going to have to do it. It's more traumatic for the fact that the mom literally had nothing to do with buying that gun. She just was a roommate of her husband by that point. She had another relationship. He bought the gun 4 days before the crime happened, the tragedy. This really sucks for her. They both had really good attorneys, both the mom and the dad, but I think the judge is going to have to deviate from the sentencing guidelines and sentence them to more.
Yeah, I agree. I mean, basically, the prosecution argued back that such a sentence as is being asked for, the 2.5 years, which means they would walk out, will be a slap in the face to the victims. I would tend to agree. The safe bet, Michael, for me, is just stick to the suggestion, which is 7 years, 7.5 years or so. That would be the safe bet. But you're right. I think in this case, she may need to or want to go over that to closer to what the prosecution wants at 10. Now, the jury will return tomorrow morning to continue those deliberations. All right, still with us, National Trial Attorney Michael Jaafar. And Michael, I'm 12 hours. I never expected that. I knew there'd be some difficulties here because of the forensic evidence, but what's clear to me, if this jury is asking about cause and causation, they think he was involved, but I think what it says to me, Mike, is that they don't believe it was his hand that killed these girls, because clearly causation wouldn't be an issue.
That's the only thing that means. A really good attorney always taught me about primacy and recency. He's now a Court TV host by the name of Michael Ayala. Some people tell me about him.
Pretty good.
I heard about the guy. Yeah, he said many times about primacy and recency, and damn, was that closing argument by the prosecution good. It was really good, because I witnessed all the evidence coming into the trial, right? There's overwhelming doubt that he committed these murders, right? Overwhelming doubt. There's no, stabbing somebody to death, but there's no, unless he's a manicurist who took their nails and cleaned them off after he committed the murder. I mean, so what if he ran? He's a criminal, right? We all know that he's a criminal. We all know that he's got dirty hands from that whole entire operation, like this Breaking Bad version of real life, just crazy, bizarre situation, right? So for them to be asking about causation, it can only mean that they want to know, hey, we have this job, and I love it when juries take their job seriously. There's so many juries that just throw people to the wolves, and we know that they made a mistake. In this case, they're taking it seriously, and they're saying, look, we're about to throw this guy into jail for the rest of his life. What's the definition? You're giving us jury instructions. Please elaborate on causation. We clearly know that he was there, but how do we overcome the burden of causation, right? Primacy and recency, the prosecution ended well with telling everybody he's the one who turned off the cameras. He's the one who ran from the police. He was the only person in the vicinity. He's the person who was there, right? He was physically there, right? And so that's got to be why the jury's asking about causation, because it matters, and I agree with them. That does matter, and I'm troubled with it as well. I was on that jury seeing what I see. I would probably tend towards saying there's reasonable doubt. That doesn't mean he's innocent, but there's reasonable doubt that he met every single element necessary for us to find him guilty.
Yeah, you got the DNA under the fingernails that doesn't match him. You got the blood at the scene that doesn't match him. He did all the cleanup. I think it's fair to say that, so they know, like you said, Mike, he was there. But again, did he do the actual crime? Not enough evidence, I think, for this jury. My question is, they didn't hear from Dean Smarrock. His name come up, I don't know, 1,000 times in this trial, and the state didn't call him. And I wonder if that's something they might be grappling with.
He has an attorney. Right? He met with his attorney. His attorney told him stay away from this with a 10-foot pole. But at the same time, we know that they could come after you for other stuff. You're a drug kingpin. So maybe he's worried about other people killing him because he would be a rat and a snitch and he'd be cooperating with the police. He's living this gangster lifestyle. He probably loves the Netflix the Breaking Bad series. He probably thinks he's Heisenberg, right? Who knows what goes through the mind of these criminals? But he definitely has an attorney who told him not to cooperate.
Yeah, criminals don't like court. They don't like police. We know that. But I think the prosecution needed to get him in that courtroom. Michael Jaafar, thank you so much for being with us. Appreciate it as always, folks.